Good evening, everyone. Thank you for joining us for another episode of the AFGE Local 17 live podcast, where we tackle the issues that matter most to our bargaining unit employees. I'm Doug Massey, president of Local 17, and tonight we have an important conversation ahead. We'll be discussing key challenges facing federal employees, particularly probationary employees, as well as the ongoing threats to telework provisions in our master agreement. We're honored to have attorney Bibi Roberts of Roberts Labor Law and Consulting with us tonight. Bibi is no stranger to Local 17. Her firm, with attorney April Fuller, won a major arbitration victory on our behalf, securing great promotions with back pay for over 40 of our members. It was one of the most complex arbitration cases I've ever been involved in, and Bibi and her team delivered an outstanding result. If you're from another local and need top-notch labor attorneys, I highly recommend Roberts Labor Law and Consulting. Tonight, Bibi will be sharing her insights on probationary status, what it means, the challenges employees face, and perceived threats to their job security. Although Local 17 has fewer than 200 probationary employees, we all remember being in their shoes, navigating a new job, learning the ropes, and trying to prove ourselves, often with a sense of uncertainty and pressure. Their challenges affect all of us because we're all in this together, and it's crucial to ensure they receive the protections they deserve. I will also be discussing the ongoing threats to negotiated telework provisions in our master agreement. With telework under attack in many agencies, it's more important than ever to understand what's at stake and what we can do to fight back. As always, we encourage you to engage. Drop your questions in the chat and share your thoughts. While we may not have time to get to many questions tonight, we will follow up later this week with a frequently asked questions section on Local 17's website to address the key points and concerns raised during the discussion. So let's get started. Bibi, welcome to the show. It's great to have you here tonight.
Thank you so much for having me. It's great to be here. So I guess I will start with my little disclaimer. Nothing that I say today is intended to be legal advice. I can't cover all the nuances that impact probationary status. It is very fact specific. Like there are a number of definitions and calculations. So nothing will be a good substitute for contacting an attorney to discuss your specific circumstances. I am going to give you some of my general insights today. But again, since this is Local 17, I'm also not covering supervisory probationary periods or anything with the senior executive service. So I did want to start with that. So I guess the positive way to put it, most people tend to have negative experiences with attorneys. We tend to tell you, no, you can't do something. So to say it in a positive way, you can say, if an agency has a valid post-employment reason and the individual does not qualify as an employee, then the individual can be terminated without due process requirements or appeal rights. That would be the positive way. The way we normally think about this is more probationary employees can be fired for any reason or no reason, but there are exceptions to that. One exception is if that reason is an illegal motivation. Another is if they qualify as an employee under the law. And the last is if it's for a pre-employment reason. So probationary employees can be fired for a number of reasons, but it has to be a valid one, meaning not illegal. They can't qualify as an employee, and it can't be for a pre-employment reason. So I will keep going back to that. So now, if the agency has a valid post-employment reason, the individual is not an employee, then they can be terminated before their tour of duty the day before their anniversary date. So if you started working at VA February 12th, 2024, your probationary period sometimes would need to be, for them, the agency to terminate you, they would have to effectuate it February 11th, 2025. Okay, so those are the basics of it. So to go further than that, probationary employees can be fired for any reason or no reason. And I say that because there has, obviously with the new administration coming in, there has been a lot of talk trying to advise federal employees. And there has been one that went around that said individuals can only be terminated for performance or conduct. That isn't correct. So you can be terminated if the supervisor doesn't like your attitude. That doesn't have to be misconduct, but it is a reason to terminate you during probation. What it does have to be is for a post-employment reason. It cannot be pre-employment. So going back to that opening, our threshold statement, probationary employees can be fired for any reason or no reason, except if that reason is a legal motivation. So let's talk a little more about that. Illegal motivation can be a number of things. One being whistleblower retaliation, which many of you have heard of. We say it as though the employee disclosed waste, fraud, or abuse. There are more technical definitions like a violation of law, rule, or regulation, an abuse of discretion, right? If you disclose these things and the agency terminates you for those disclosures, that would be an illegal motivation that is not permitted to terminate an individual working for the federal government. Another one that is appropriate for this discussion is protected union activity. You don't have to be a member of the union, but say you engage in a grievance, say you go to the union for assistance, or you join the union. If you are terminated for any of those reasons, that would be an illegal motivation that is not permitted. Then you have marital status for those competitive service employees, and we'll talk more about that in a second. Marital status being that your termination was based on being married, being single, or being divorced. That would be an illegal motivation for competitive service employees. If it is for your partisan political status, basically that you affiliate with a political candidate or party, that would be another basis that's illegal to terminate a competitive service employee. And then the one we all know of would be any Title VII reason. So if it's based on your race, your color, religion, sex, national origin, age, or disability, that would also be an illegal reason. So if you can prove any of those, you would then have a basis to challenge your termination, even though you might be in a probationary status. So now we'll go back. Probationary employees can be fired for any reason or no reason. The other exception we talked about was a pre-employment reason. So you want to think about pre-employment as though there has been some normally deception on your application. Maybe you didn't tell the truth on your OF 306, and you do have a family member, a husband, a daughter working for that same agency. Say you lied about your qualifications, anything pre-employment, maybe you lied about a conviction. Any pre-employment reason would not be, there are limited due process requirements for pre-employment reasons. And that would be advance written notice, an opportunity to respond, and a written decision. You're also allowed to appeal that decision if it's based on a pre-employment reason, but that appeal is limited to just making sure the process was followed. So that you got that advance written notice, that you were able to respond, and that you got a written decision. So it's very limited appeal rights. Okay, so now we talked about pre-employment reason. So probationary employees can be fired for any reason or no reason, except they qualify as an employee under the law. So I left this one last because it is the biggest one. Okay, so you can be an employee, and if you are an employee, the Constitution has been interpreted to allow federal government employees property rights in their employment. So that property right cannot be deprived without due process. And so for this, due process for an employee requires advance written notice, an opportunity to respond, a written decision, and you get appeal rights. You get to have review of the decision, not just the process, the merits of your removal. That's important because the first thing you want to think about is, were you even a probationary employee? So I started at the top by saying, if you've already completed that probationary period, if they fail to effectuate the termination before you completed that probationary period, you are an employee. So if you started work February 12th, 2024, they had to effectuate that termination by February 11th, 2025 for competitive service employees. If they don't send me a notice until February 12th, 2025, they're too late, and I've already completed my probationary period. So I am an employee, and that removal would get overturned immediately because they failed to give me my due process rights. So that's first. First question, are you a probationary employee or are you an employee? Now, the next part talks about whether you qualify as an employee, even if maybe you didn't finish your probationary period. Okay, so that sounds strange. So you have a probationary period. It's 1 year for competitive service employees, 2 years for most accepted service employees. But there are people who meet the definition of employee before they complete their probationary period. So it's important to remember these two things are not the same. You can be in a probationary period and still qualify as an employee that is entitled to full due process rights and appeal rights. So I just want to talk about that difference for a little bit. So we will start by an individual is an employee if they are not serving a probationary or trial period under an initial appointment, or they completed 1 year of current continuous service under other than a temporary appointment, limited to either 1 year for competitive service or 2 years for accepted service. So I mentioned that a couple of times now. There is a difference between competitive service and accepted service. There's also the senior executive service. So we do have different service systems in the government. For our purposes, it's just the difference between competitive and accepted that matters. People often ask, why is one accepted? Why is one competitive? It's really just up to OPM. OPM decided they didn't want to handle certain positions in the competitive service, so they don't. So most federal government employees are in the competitive service, but we do have some, like any attorney advisors, you would be in the accepted service. That difference does matter for probationary status. So I will talk about both of them. So let's start with the competitive service. That is most employees, Title V. If you're a hybrid employee or Title 38, this is not about you. If you're an attorney advisor in the accepted service, not about you. How do you know if you're in the competitive or accepted service? You can look at your current SF50, any one of them. It could have been one dealing with the increases at the beginning of the year. It could be one that gave you a WIGI. Anyone dealing with your current position. You want to look in box, I think it's box 34 on your SF50. So it's towards the lower part of the page on the left-hand side. That will have a number in it, and it will tell you if you're competitive service or accepted service. There will be a 1 if you're competitive service and a 2 if you're accepted service. So if anyone's questioning, how would I know which service I'm in? Looking at your SF50 of your current position will let you know. Okay? So now, if you're in the competitive service, you have to complete 1 year of federal civilian service to complete your probationary period. You can look at your effective date on your SF50. Sometimes SF50s can be wrong, but for the most part, your start date is correct. So you can look at your SF50 for that. And then you just look, the day before would be the date your termination would have to be effected. Other things to remember, some people think if I'm absent from work for a long period of time, what happens to my probationary period? Any absence while in a pay status counts towards your probationary period. So if you use annual leave or sick leave, that counts, even though you're not working. If you're in a non-pay status, like leave without pay or AWOL. Now, if you're AWOL during your probationary period, you're likely going to be terminated anyway. But let's just say you're on leave without pay. Because you're in a non-pay status, it counts up to 22 days. Anything over 22 days can be added to your probationary period. So if you had leave without pay for 30 days, the agency can add 8 days to your probationary period. Okay, so it's important to remember that. And the other thing to remember is that if you're in a non-pay status because of workman's comp or military duty, those still count towards your probationary period. And there is no cap. They're just applied when you return to the agency. Okay, so leaves of absence, if you're on leave, pay status, that counts. Non-pay status, it counts up to 22 days, unless your non-pay status is because you're on military duty or workman's comp, then all of those days count. Okay. The other thing to remember is how else can you meet your probationary period? Some people have heard of something called tacking on service. Tacking on service means basically you completed a probationary period prior to your current position. This happens a lot with temporary appointments. Some people have had multiple temporary appointments with the agency. Some just have one, but maybe you've completed 1 year of service under a temporary appointment. You're allowed to tack that on to your current service as long as you are in the same agency, in the same line of work, and you did not have a break of service of more than 30 days. So that's really important. Same agency, same line of work, no break in service of more than 30 days. The same line of work is determined by whether or not your actual duties were the same. And we all know you can have a PD that says you do certain work and it's not the work you actually do. So they're looking for what is your actual work, and they're comparing those two from the position you were in where you might have completed a probationary period and the position you're currently in that you're being terminated from. Okay, so we normally see that with temporary appointments, but it has to be same agency, same line of work, no break of more than 30 days. Now, the alternate way you can meet your probationary period is for current continuous service. For current continuous service, for competitive service employees, you don't have to be in the same agency or the same line of work. You could have come from the IRS, come straight to VA without a single day of a break in service. You can then add that time at the IRS to your time at the VA and have complete and satisfy the definition for employee with due process and appeal rights. Okay, so that's the competitive service. One trick with that is that I did say it is an alternative. You don't have to meet both. So you can either be out no longer in a probationary status in your initial appointment, or you can meet the current continuous service definition. So there are employees who might go on, say, leave without pay for 60 days. And an agency might decide, well, now we're going to extend your probationary period by the extra 38 days. Remember, 22 of that non-paid time counts, but the other 38 wouldn't have. So the agency can say, we're going to extend your probationary period by those 38 days. Well, under MSPB law, that employee meets the second definition, current continuous service, once they've met the 1 year mark, because being in a non-pay status does not constitute a break in service. So they did not meet the first definition of completing a probationary period, but they met the second definition of over a year of current continuous service. So I told you probationary periods get tricky, and that is one of those ways. But that employee would have met the definition for employee because they did more than 1 year of work even though they haven't yet completed that probationary period. Okay. Now let's talk about accepted service and what the difference is there. So at the top, I mentioned accepted service employees cannot appeal their termination, their probationary termination, based on marital status or partisan political status. Okay, so that's one thing to remember. Any attorney advisors, if you believe you were terminated for that reason, under probation, you cannot use that to appeal. If you're an employee, you can appeal for any reason. But if you're not an employee in accepted service, you cannot use marital status or partisan political reason to appeal. For accepted service employees, that probationary period is normally referred to as a trial period, and it is for 2 years. The thing that's important for accepted service employees is whether you are a preference eligible or a non-preference eligible. Okay, so we started with probationary status. We broke that down into competitive service or accepted service, but now accepted service is getting broken down into preferred, preference eligibles, and non-preference eligibles. Okay, we'll start with non-preference eligibles. And if you don't know if you are one of them, again, you can look at your SF50. This one would be box 26, and it's on the right-hand side, lower right-hand side of your SF50. You'll see a box that asks about veterans preference. There will either be yes or no. If you're veterans preference, you're more likely a preference eligible. If it's no, then you're not likely to be one. But the definition is very specific. I couldn't give you advice on that without seeing your particular circumstances, but you can go to 5 USC, US Code 2108, Section 3, and it gives you the definition of who qualifies as a preference eligible. It's some veterans, not all veterans, and their close relatives, not all relatives. Okay, so that's important to know. Not all veterans are preference eligible. You do have to meet the definition in the statute. So a non-preference eligible can meet the definition of employee if they are not serving a probationary or trial period under an initial appointment pending conversion to the competitive service. Okay. Or just like what we talked about for competitive service, there is an alternate way to meet it. Or they completed 2 years of current continuous service in the same or similar position in the executive agency under other than a temporary appointment limited to 2 years or fewer. Same or similar for accepted service is very specific. So there was a case where an individual had 2 attorney advisor positions. So he had held one attorney advisor position where his duties were to assist the agency in litigating employment discrimination complaints. In the other position, he was advising the agency on disciplinary actions. So still an attorney advisor, but different duties. MSPB found that it was not the same or similar position. Same agency, still an attorney advisor, but they found it to not be the same or similar position. So he had to do a new probationary period when he switched the attorney advisor position. So for accepted service, it's really important that the position is the same or similar in order to not have to do a new probationary period. Okay. Similar to competitive service, prior service can be tacked on. Again, it has to be the same agency, same line of work, no break of more than 30 days. For preference eligibles, you have to complete 1 year of continuous service in the same or similar position with an executive agency or the U.S. Postal Service. This is important because just like with the competitive service example, there are a number of preference eligible employees who become employees by definition after 1 year of work, even though they have a 2-year probationary period. All right. So if you're an attorney advisor for the board and you have a 2-year period, but maybe you're a preference eligible, then you might only really have 1 year of service where you are now entitled to full due process rights, and you get an appeal. You get appeal rights. Okay, so it's not about your probationary status. The question is, do you qualify as an employee? Similar to competitive service, there is tacking on allowed for accepted service, but it works differently. So for accepted service, anytime you spend in a temporary position does not count towards a permanent position. So if you're in a permanent position and you're being removed during your probationary period, you can't use time from a temporary position to tack on. And the same goes the other way. If you had a permanent position and you move to a temporary position, all in the executive accepted service, then you move into a permanent position after that, you still can't tack on that service. So you'll have to do a new probationary period. So it works a lot differently for accepted service employees. The main difference is that accepted service employees always have to have work within the same position, whereas competitive service employees can use time in a different position to satisfy the current continuous requirement. Okay, so that's the main difference. It's important to remember Title 38 employees don't have MSPB rights at all. And then hybrid employees do, but they don't have regulatory rights to appeal marital or partisan political status. Then the last part I wanted to talk about is where to appeal. That's always the question. Since this is a union call, right? This is Local 17 hosting this meeting. One of the main points is that it's rarely appropriate or grievable to file a challenge to a probationary employee's termination. The one exception is if your argument is that you are an employee, okay? Because employees can always grieve. So if your argument is that you did complete your probationary period, or you satisfied one prior to this position, or the agency failed to effectuate it in time and now you've become an employee, that is the only circumstance it's appropriate to grieve the termination. Otherwise, you want to challenge it in the MSPB. If you're competitive service and you're claiming it was based on partisan political status or marital status, you want to take that to the MSPB. If you believe it's because of your race or your sex or any of the Title VII reasons, you want to take that to EEO, starting with the ORM department. If it's based on any union activity, you want to take that to the Federal Labor Relations Authority. And if you think it's because of your whistleblowing, you want to go to the Office of Special Counsel. So those are the general basics for probationary employees. I'm sorry it's so much information, but again, there's no substitute if you're in a situation where you're terminated to going to the union for assistance or getting an attorney to talk through your circumstances.
Thanks, Bibi. I was thinking, when I started as a union advocate about 12 years ago, when people who are on probation came to our office and said, I think I'm going to be fired, we said, sorry, there's nothing we can do for you. And maybe we'd see if they were really, were they probationary? Is there any kind of, do they have any prior continuous service? Something like that. What we have been doing at Local 17 is that if somebody comes to us and they say, I'm going to be fired, we try to go to the supervisor. And a lot of times we have about a dozen stewards. And if we know somebody with a good relationship, we'll say, hey, what's really going on? Is this person salvageable? And we've actually prevented people from being removed like that. I think there was one in which the supervisor used to be a union officer, and the supervisor above that was a friend of mine, and they both said, sorry, they're just not getting it. And I don't think it's going to be a very, good fit. And we just said, we're very sorry. But you're right, most of the time, there's nothing we can do. And let's face it, a lot of you're here tonight because you're on probation. And we all know that Elon Musk and Doge asked for lists of people on probation. And their goal is to get rid of a large percentage of the workforce. I did see some information that came out on a tweet. I guess that's how a lot of people get news these days.
Mm-hmm.
But it should be reassuring for people here at the VA because, when they come out, they want to make life as miserable as possible so people quit. Ending telework, having shitty buildings, have long commutes, things like that. Now, I know that there's certain agencies they don't like. They don't like Department of Education. They don't like Department of Labor, EPA. Department of Veterans Affairs is a little different. So I did hear something that came out that said they're not going to just fire all probationary employees. They're not going to do that. But they're going to look at you with a little more scrutiny. And let's face it, it's, somebody over at Doge or the White House is not going to see your work and say, this is terrible. It gets down to people. And you're going to have a supervisor, and that person is going to have a supervisor. And if you can work with that person, and if they're not out to, and I don't want to say this is a management initiative. It's not. This is a White House initiative. And I got to say, managers, senior executives, they're almost more worried than we are, than most people. AFGE this weekend, Sunday till today, had a legislative conference. And we had 700 AFGE officers and stewards from all over the country come to Washington, D.C. And they're from everywhere. I was just talking to somebody from ICE, Border Patrol, Social Security, HUD, Department of Defense, VA. VA is about a third of AFGE members. And people are if you're feeling like you're alone, like, oh my God, I'm on probation, I'm going to get fired, I got kids, I got bills. They're everywhere. People are scared to death. And it's important to understand you're not alone, especially in this virtual world where you get very depressed because you're by yourself and you're not talking to coworkers. And I hope that, the union can be a way where we create some kind of sense of community and where you can talk to us. Because I remember what it was like when I was on probation. I was told, somebody said, you show up, you put up, and you shut up. And I started this in the same day as somebody who's a VLJ. And he was scared to death about getting fired. And I remember he came to me in a panic. And he said, I was in the men's room and I told a dirty joke and my boss was there. I didn't see him. And I was like, well, what was the joke? And he told me, I said, it's not that bad. And you're in the men's room. It's not like you're at the cafeteria. And not only did he make it, but he was one of the most successful attorneys I knew there. Now he's a veterans law judge. But so it doesn't mean that you're going to be fired because they're looking for lists. And I know they asked for people with performance problems. And somebody said, well, I had something that says needs improvement. That doesn't mean you're going to get fired. And I talked to somebody, they're involved in the records, updating all the medical records, which is a huge push. They've invested, billions of dollars. And you're essential. They need you. There's other offices, too, that people are very essential, and they can't afford that. The Board of Veterans Appeals, they've had an attrition rate that for 5 years, it was like a Walmart on a Sunday, people going in and out. They need people there to write the decisions and to get the backlog down. So that we have a little more job security, I think, at Department of Veterans Affairs. If you're on probation, yeah, they might look at you with a little more scrutiny, but they could have done it anyways. I mean, if you have a supervisor and they were going to get rid of you during your trial period before this whole Doge thing came out, they're going to probably do the same kind of thing. They need people in the job. It takes a while. Any job takes a while to be trained. So I just want to put that out there. But anyways, I want to thank Bibi Roberts. Not only did her law firm, she got 40 people back pay. And I've gotten comments that we focus a lot on the Board of Veterans Appeals and not other areas. Half our members are from the Board of Veterans Appeals, half our bargaining unit. And I was thinking about since the pandemic, most of our arbitrations have been non-board related. There was OINT employee who got suspended. Steve Eckerman got that reversed. Somebody got denied full-time telework and they were sent to some lower graded position. We got that reversed. Somebody from NCA, actually Bibi Roberts handled that, got her reinstated with back pay. So we are doing the telework arbitration. of 50%, McDonald's 50% in-office attendance requirement. That does not impact the Board of Veterans Appeals. We're doing that, taking that to arbitration. I was told when I started, somebody in our national office, I was handling a lot of canteen cases, the dishwashers. And he was like, what are you worried about them for? And I've personally dealt with 6 removals personally with a canteen and been effective at 4 of the 6. And they have no rights whatsoever. It's more, talking to people. So it doesn't matter who you are. I don't care what your position is. If you're being harassed or you're having a problem, we're going to look out for you regardless of where you are at VA Central Office. That's the culture that we've created, and that's the culture we will continue to do as far as fighting. But Bibi, I want to thank you for being here. I'm going to talk a little bit more about telework. And if you want to, if you're from a local, beyond Local 17, her information is there. Her number 202-235-5026. So thanks, Bibi. We appreciate it. Bye-bye.
Take care.
So we did a podcast on telework, and there's been some new information that's come out in the news. And basically, the White House has said, we don't care about collective bargaining agreements. The hell with that. We're going to cancel telework. So actually, one of the biggest concerns we face is the possibility of VA eliminating or severely restricting telework. And if that happens, we're going to file a grievance and take it to arbitration. And based on the law and past decisions, we believe there's a high probability that we will win that arbitration. Now, this won't be the first time that VA disregarded the contract. As you know, former VA Secretary Dennis McDonough already violated the master agreement by imposing the 50% cap on telework, and a clear violation of Article 20 of our master agreement. And we are taking that to arbitration. There is an update. I'm sorry to say that that was scheduled for February 28th. The opposing counsel had that moved to May, and she made a bunch of motions to get rid of it. Because of President Trump, and that has no relevance. But and she did that because basically she's lazy. We've dealt with her before, and I don't want to mention any names, but her initials are Barbara Burke. She's an Office of General Counsel. So we're going to have to wait. They say justice delayed is justice denied, and I'm so sorry for that. But arbitrators do like to make the parties happy. They get selected by both parties. So here's the thing with respect to winning an arbitration. Where was I? However, even if we win in arbitration, the VA can appeal that decision to the Federal Labor Relations Authority. And that's where things kind of get complicated. Because if the department appeals, the remedy is essentially put on hold until the FLRA, Federal Labor Relations Authority, makes a ruling. And with the current FLRA, it's very anti-labor. Basically, there's 3 members usually. 2 can only be from the same party. So there's going to be 2 Republicans, 1 Democrat. Right now, there's only 2 people, 1 Republican, 1 Democrat. There's gridlock. So if we win an arbitration, it's appealed. It could be sitting there at the FLRA for years without any kind of resolution. So basically, that is a problem with just about everything we're going to be doing over the next 4 years, because the FLRA kind of superintends the bargaining process. They superintend the relationship between federal sector labor unions and agencies. So what can we do about it? While we will pursue legal action, we need to help to build public and political pressure. And the VA needs to know that employees across the country support telework and expect the department to honor its commitments. One of the most effective ways to make an impact is by writing to your representatives in Congress. This is especially important if you live outside the DC, Maryland, Virginia, the DMV area, where members of Congress may not be hearing as much about federal workplace issues. If we show lawmakers that federal employees nationwide care about telework, they will be more likely to step in and hold the VA accountable. Since we won't have time to answer everyone's questions tonight, we are going to be posting a section of frequently asked questions on our website later in the week to address your concerns. So every podcast, we have somebody look at all the comments and we'll have questions and answers for everybody to take a look at. So this is a fight. We have to take this seriously. Telework is worth defending, and we're not going to back down. And we all know that before the pandemic, it was very strange being a union advocate because they were trying to limit telework. They looked at it like it was compressed work schedule, like a day off. And then the pandemic struck, and everybody was working at home. And what happened? Everybody became more productive. And I think, personally, I did not want to telework. They had to. I was threatened with discipline. I remember it was March 2020. I had to go home. I was going to be disciplined. I went home. I started teleworking. Now it's very difficult for me to go to the office. It's just, and I get much more work done. And I think everybody does the same thing. You get up earlier in the morning, and if you get up at 6 o'clock, you may turn your computer on at 6:30 and start working. You may have something that you left off, and you're like, it's Saturday. I'll turn my computer on and finish it. McDonough's 50% in-office attendance requirement. That was not a performance-based decision. That was a political decision because the mayor was upset about businesses in DC, restaurants, things like that. And I don't blame her. If I were her, I'd be advocating for that. But the policy now with eliminating telework from Doge, from Elon Musk, President Trump, this is their philosophy. Make everybody as miserable as possible. You have a shitty commute, you got to come to the office, and maybe these people will quit. And I think that's a terrible way to approach any kind of workforce. I mean, if you want, most managers, they care about an engaged workforce. You want the enterprise to be successful. They don't want the federal government to be successful. They want us to fail. They want to privatize VA. They want to get rid of agencies. And I heard Doug Collins' testimony on the Hill. He sounded sincere that he really wanted to run the VA and take care of veterans. And I kind of think I believed him when he said that. I don't think this is really helping. What's coming out of Doge is helping him. He's got to navigate a very difficult political landscape. But I think the best advice I can give people is, yes, write your congressman, write your representatives in Congress. But also remember, we still have a job to do, and we need to take care of veterans. So whether you're at VHA or NCA or OINT or VBA, the Board of Veterans Appeals, it's important to just try to focus on the work and try to not listen to all the news. And personally, I stopped watching the news a while ago. I watch local news. I do get information. Obviously, I have to get it for this job, but I try to limit my sources and where I get it. And frankly, my wife and I, we watch forensic files at night instead of the news. We find like spousal murder is actually not as depressing as the news. And we're on season 3. But it's very difficult to watch sometimes. It's like watching a train wreck happen in your own country and things getting dismantled. So anyways, we do appreciate your support. We've gotten a lot of new members. In the last month, I think we've gotten 380 new members, and we appreciate everybody. And we're going to try to service everybody. Our goal is if somebody writes to me, they need help, we try to respond within 24 hours. And we look at this is about customer service. I think 380, somebody just said. And this is all about customer service. And trust me, the stewards we have, they are working overtime. I feel terrible for them. I load them up with tons of work. They're working weekends and to help everybody. And we're all committed because we know what it's like. We're one of you. And we feel as though we have this big responsibility. But, we've gotten incredible insights and help from our members. And we might do a campaign of writing our representatives in Congress, having petitions, things like that. And the one good thing about Local 17 working for you guys is everybody comes through. And I remember it was before the pandemic, some manager had a portrait of Nathan Bedford Forrest on his wall, the founder of the KKK. And he was a real dick, especially to black people. And we didn't, like, we don't know if, he's racist or is he just a dick. And when we saw that, we decided, I emailed people. I said, I'm going to have a petition in the cafeteria for people to sign. And we got like 300 signatures. We had senior executives signing that so I could give that to the secretary. We had people from the Office of General Counsel. And it's, and when they were signing it, there was a guy I had filed grievances on. He's this black guy, he's signing it. I said, you can get fired if they catch you. He's like, I don't care. And people come together when they realize that, when they stand up for what's right and what's just. And I know people are afraid, job security, we have families, we have mortgages, whatever. Everybody's got expenses. We didn't come to VA for the fame and the money, right? And we have a job to do. And, to vilify us is just, I think it's pathetic. And, I went to the rally and they say we're heroes. I don't know if we're heroes. I don't know if we're villains. We're just people trying to do a job, and we're trying to do a good job. And I think that's human nature, regardless where you work. I once worked in this crappy factory. It was terrible. And I was amazed. I was a young guy that a lot of these people worked there for years. They were so concerned with doing a good job, and that I really marveled at that it doesn't matter what you do. It's just part of our DNA to want to do a good job. And these people don't get that because these people don't work. These people have really never worked. They've never been in a factory. They've never been in an office 9 to 5, having pressure and phone calls and things like that. And that's unfortunate that we got some billionaires who think they know what's best for working class people. But let's try to get through this together. And we all appreciate everybody's membership. So thanks for coming here. And we will be doing another one of these pretty soon. We're going to be doing reasonable accommodations, and I think that's coming up on the 26th of February. So if you want to learn how to apply for reasonable accommodation, we will keep you posted. So thank you, everybody. Have a good night.